what's going on is quite simply the consequence of a Supreme Court that is rewriting the Constitution. It is the consequence of the living Constitution. It is a consequence of the Constitution that changes. And the Constitution for whose changes the court is responsible. Once the people figured out that that's what's going on, it took them maybe 30 years or so to figure that out. The people aren't stupid, and they say, oh, well, we used to look for good lawyers. Somebody with a modicum of judicial demeanor, an honest person, all this stuff. That's not the most important thing anymore. This court is rewriting the Constitution. I should pick somebody who will write the new Constitution that I like. This is not, isn't that inevitable once you know what the job is? I think it's inevitable, and I think the process will remain that contentious as long as the court stays with the relatively new notion of a living Constitution. We should not be proud of the fact that we don't agree upon what we're looking for when we interpret our Constitution. That's not a satisfactory system. Anyway, we're not back there yet, but maybe we're on the way. I've noted many times that it's hard to get back to where we were because the philosophy of the living Constitution, which means it doesn't mean what the people agreed to when they adopted it, is a very seductive theory. It's seductive for judges because it empowers them. It's seductive for law professors because it lets law professors let their imaginations run wild. So it'll be hard to get back there, but we're on the road, and it's a fight worth making. Even if we're not successful, a thing worth doing. One of my favorite Chestertonian paradoxes: a thing worth doing is worth doing badly. I have to make one exception to the improvement of situations in the courts. I think United States courts have improved, but over the last few decades, the contagion of living constitutionalism has spread abroad. Canada adopted a Bill of Rights, which it soon interpreted to be a living tree, echoes of our living Constitution. The Court of Human Rights in Strasbourg, which interprets the Convention on Human Rights of the European nations, announced quite early on in its life that the convention was to be interpreted currently according to the needs of the current time. Essentially, it also is a living document. That, by the way, is why courts of other countries cite American Supreme Court cases, and why some American Supreme Court cases cite the courts of other countries. Because if, in fact, we're not looking for what a particular text meant when it was adopted, but rather we're looking for what that text ought to mean in the world we now live in, then what other courts think is indeed relevant. You know, they're smart fellas over there. So why shouldn't we? I mean, after all, when they were writing a constitution rather than interpreting one, the framers cited international examples repeatedly. Read the Federalist Papers. So why should, if a court is rewriting a constitution rather than interpreting one, it should logically do the same. So that's what's been happening both in this country and abroad